Welcome to Legal Studies. Today we're going to be learning about the role of the judge, jury, parties, and legal practitioners in a civil trial. So where are we in the study design? Well, here we are, where we're learning about the responsibilities of our key personnel. In the last video, we learned about the judge and the jury. Today, we're going to be learning about the parties and the legal practitioners. So let's start with the main role of the parties. You've got two parties to a civil case. You've got the plaintiff, who are the party bringing the case or claiming that someone has done something wrong. And then you've got the defendant, who are saying, no, I didn't do anything wrong. And their main roles, first of all, is to make decisions about the conduct of the case. And we call this party control. And what that means is that these two people, the plaintiff, the person who says they've been wronged, and the defendant, the person who says they've done nothing wrong, these two people have full control over the strategy of the case. They get to make decisions about what witnesses to call, what evidence they're going to use, what legal arguments they're going to make. All right, these two people, the two people affected most by the case, are the ones who make the decisions about how to run the case. Now, usually they hire lawyers to help them make these decisions, but at the end of the day, those decisions are theirs. They also have some other responsibilities, such as, for example, they have to discover any relevant documents. So what that means is any evidence that's relevant to the case, any documents that they have to turn them over to the court and to the other party so that everyone knows what's going on. And finally, the parties have to comply with what we call the overarching obligations. Now, these are certain obligations or requirements that you have to the court to act in an honest way. You can see here, I've put them down here. There's 10 of them. They're sort of like the 10 commandments of being a good party in a civil dispute. You have to act honestly. You shouldn't be making claims that are unreasonable. You should cooperate with the other side. You shouldn't mislead or deceive. You should try and make sure that costs remain reasonable, that you're not delaying things, that you disclose all of the relevant documents. So these are the things, the obligations you have, basically to be a good party, to make sure that the case is going to run smoothly. So some strengths and weaknesses of the parties. Well, first of all, party control means that each party gets to make their own decisions about the best way to run their case, which means they're more likely to be satisfied with the process and hopefully with the outcome because they're in control of it for the most part. On the other hand, some weaknesses of that is that unrepresented parties can cause delays or be disadvantaged. Since this process, the civil trial process and the pre-trial procedures and all that can be very highly complex, and they may not know what to do by themselves. And on top of that, they might have difficulty, even though they've got control over the decisions that they're allowed to make, they might have difficulty knowing what the best decisions are. Because if they're not a lawyer, they may not have the knowledge they need. And even though they have these overarching obligations that they have to follow, it can sometimes be really difficult to prove if they're not following those obligations. For example, if they're trying to hide documents, they're not turning over all of the evidence to the other side, that can sometimes be really hard to know. Right? How do you know if they're not turning over relevant documents? You don't know what you don't know. And then we've got our role of the legal practitioners, our lawyers. Now, often the legal practitioners will act on behalf of the parties and undertake a lot of the parties' responsibilities as well, because usually the parties aren't legally educated, and so the legal practitioners help them run the case. So what are some of the things that a legal practitioner will do? Well, they'll make opening and closing addresses to the court. They'll present the case to the judge or jury, so they'll examine witnesses, they'll make legal arguments, and they also have, same as the parties, they have some overarching obligations to the court, same as the parties. So they have to act honestly, they have to make sure that they're not causing delays and things like that. So they've got the same overarching obligations that the parties do. Some strengths and some weaknesses of the role of legal practitioners is that they can, first of all, they can assist the parties in making the decisions and navigating the complex areas of civil procedure that they need to navigate. So they sort of work hand in hand with the parties. And lawyers are required to assist the court to achieve justice because of those overarching obligations, which means that they should be, and in most most cases they are working towards trying to make sure that justice is achieved, that the right outcome is achieved, that no one is being misled, there's not as many delays, that sort of thing. On the other hand, some weaknesses, sometimes the overarching obligations to the court and your responsibility to present the client's case in the best possible light, sometimes they can be in conflict. And if that's the case, then the lawyer has to follow that obligation to the court. Of course, using a lawyer can add to the cost of a trial, and because of this idea of costs and legal fees, better representation, more expensive representation can lead to one party getting a better outcome than the other, which can create inequality in our system. And that's it for the roles of the judge, of the parties and the legal practitioners.